Hello and welcome to another episode of PrivacyCast Season 3. I'm your host Akarsh Singh, and our goal on PrivacyCast is to bring you the latest insights and perspectives from the privacy industry. The question that we want to ask you is, oh boy, am I missing what is going on in privacy industry? And this is the podcast that answers your questions practically in privacy. And today we have Mr. Manish Mishra, the data protection officer of Maastricht Bank. He is based out of in Dubai in UAE and has an impressive list of past, by the way, and also certifications. You name it, CIBPE, DCPLA, DCPP, CISM, ISOLA. He's certified with everything, and also he heads co-chairs the chapter of IAPP in UAE. He also in the past has worked with Big Fours, and he's also one of the people who started the privacy journey when GDPR came in. So I think we both have been here for so long. It's a privilege to host you here. Our today's discussion will be specifically focused on his current area of focus of privacy, which is the UAE's PDPL, the UAE Personal Data Protection Law and Privacy. This law was introduced last year, and now we are awaiting some confirmations. So we would like to hear a lot from Mr. Mishra is what is going to change, how the world is going to look in coming days. He has wealth of experience, and without further ado, let's hand it over to Mr. Manish. So can you tell us what is a normal day as a data protection officer in the banking sector?
Hi, everyone. Thanks, Akarsh, for having me here. And first of all, thanks to your team for arranging this. So, Akash, that's a very good question. DPO as a role is still evolving. And in my day-to-day, life, whenever I go to office, right, a typical day is I will say, looks very exciting and full of challenges. I can very well say that, and with a lot of confidence, I can say that as a DPO, you will never see, the dull day coming your way. It's always something new that I do. So typically, as a DPO, you of a bank or of any firm that you name per se, the key objective is basically starts with keeping track of the regulatory changes that happens under the regime you are looking at. Today, every business and organization wants to grow. So you need to be there and help them in their growth journey by, enabling better transformation, by enabling, the data access, data movement, and, helping them in taking the right decision while developing a solution, product, or a changes in a process. So that's where your learning around privacy by design comes into picture. Then you also get to get a taste of, data subject requests on and off that comes thanks to new tools and technologies that enable that, and thanks also to the customer who are aware to and understand that yes, they have a right which they can exercise and put the organization in question. Last but not least is basically the events, if any happens, like a data breach or a data leak that happens, the detailed assessment of those, ensuring that controls are in place, and the data which is throughout the organization moving is protected. And you also, along with it, you also need to have your personal obligations where your learning should happen on a day-to-day basis. Privacy is very evolving. Every day you will see, something new happening, something new being released in terms of guidance, in terms of fines, in terms of events that are happening. So you need to keep abreast yourself with new technologies, new changes, and new market movement, so that you can leverage that into your day-to-day experience, and you can give the right set of advice to your organization and as well as to your customers.
Right. I think that kind of is an exciting world that you just told, because one thing that we should all know and remember that the job of a DPO is very new, unlike other job profiles in an organization, and we are all learning. So I think somebody at your level who's doing that experience, I think it's gold of experience as a data protection officer right now in the industry, because we are all figuring out what has to be done. I think if you have figured out so many things, I think it's a privilege to speak to you. So coming to the question, right? I know our audience has been asking us a lot on YouTube comments and LinkedIn comments that what is this difference between the GDPR and the upcoming or the available draft of the UAE's PDPL? So what is this difference that you see? And also a question to that is, if a company is already GDPR compliant, do they need to change a lot, or the difference is not a lot?
Sure. So I would like to look at from a perspective that the GDPR as a regulation, and I really respect that regulation. It's basically the defining platform of all the privacy regulation. You talk about regulation not just UAE, but you talk about regulations in Bahrain. You talk about the earlier India regulation was pretty much influenced by that. You talk about regulation like ADGM, Abu Dhabi Global Market, and DIFC. They are also, kind of, derived from that. Similar goes with Saudi. So UAE PDPL is also in most of the cases pretty similar to GDPR, and but there are few places where it differs also from GDPR, where in this region consent plays a very important role. So they have given a lot more emphasis to consent in the regulation. There is some variation in terms of data subject rights that GDPR gives vis-a-vis the UAE PDPL gives. There is also similar obligation from a data transfer perspective, but UAE PDPL make it more stringent, and it also tries to bring a concept of risk-based assessment when it comes to data movement and data going out of the boundaries of jurisdiction. The key thing here is to see is that the UAE PDPL exempt sectors like banking, banking and credit related data, health sector, government entities. Whereas GDPR was one umbrella that covers everything. So that is one prime difference, and it will be very interesting to see in the times to come that a bank or a health insurance provider who is currently exempted from PDPL will be a processor or a sub-processor for an entity that is covered by UAE PDPL. So the obligation will in turn comes and transferred to these entities indirectly. The second interesting point for which I'm pretty excited and I'm waiting about is what happens to employee data. Because current banking sector framework, the current health sector framework, and few sectoral specific, free zone specific regulation, they don't talk or specifically include employee related data. And UAE federal data should include this employee data, because currently the employee data has very limited to no protection when it comes to privacy regulation. So Consumer Protection Regulation, CPR, which covers bank, and the federal law for health, they again focus on data attributes, and they address customers and the patients and the relevant data. But employee data, where all the monitoring is happening, where also much of processing is happening these days, and post-COVID, there is a diverse workforce that is spread out. All those need to be baked in to take care of such nuances and to address the concerns that are rising from such data.
Yeah, and I think I'm also trying to take in from this conversation is that cross-border transfer as well as consent are two very important things. And the third thing that I kind of got is the employee data, whether it will be covered or not, and what will happen with the free zone is the question. Also, that is, what are these principles of UAE's PDPL that will become very important tomorrow for an organization to implement?
Sure. The principle that UAE PDPL follows is almost similar to GDPR. But I think the key factor or the key principle that will make difference is basically the legality principle or the legal basis of processing, where consent is one of the important pillar that is holding its ground, where you have other legal basis under which the data could be processed. Secondly, the risk derivative of those processing that you are determined from the processing activity will become important. And storage limitation. So know that data retention and deletion is important. Now, there are 5 regulation, that might be applicable on an entity as a whole. So what those 5 regulation will have different sort of retention period requirement. So which will supersede with whom, how do you manage conflict in such a scenario will become very, very, interesting to see. Last but not least is basically accountability. So like GDPR, the data office is said to be established. There will be, governance that will be coming on this regulation. So how and to what extent the organization, the data controllers, joint controllers, and the data processor will become accountable by the authority will be an interesting aspect to see, because once the example is set, that's where the future course of action for the similar set of industry or the sector related companies will get determined.
That's a great summary on the UAE's data protection laws, privacy principles, as well as what has changed from GDPR. And in terms of legal basis, what is coming and what we can see and how things will be different. Moving on. So, what we have also seen is one of the very important things as GDPR does is also they kind of obligate the other countries to build their own privacy laws by putting a small requirement in cross border data transfers as adequacy. So, do you think, Mr. Mishra, that by getting this law as the country, as a country as UAE, would the country also is looking forward to get adequacy decision?
Yes, that is very important for this, country per se, because we all know that UAE wants to become the digital and innovation hub of the globe, of the world, right? And recently, the government has changed a lot of regime in terms they are inviting talent across the world to come and work for UAE as well as from UAE, right? So that's where, in order to give that confidence to the businesses, give that confidence to the individual, uh, getting this law into place and then building the framework around this is very important for UAE, because one side, you can become an innovation hub only when people whose data you are processing, the companies who are going to operate out of your jurisdiction feel comfortable, and they get that leverage that the jurisdiction has equivalent level of advocacy controls in place and the framework in place, so that the data movement can happen seamlessly. So, and I think this is also true from a reverse side. So UAE PDPL also imposes limitation on international transfer. And whenever this data is moving outside UAE, and the data office that is going to be established or set up, they will issue a list of favorable jurisdiction or jurisdiction with advocate protection, where the data can be exported without a lot of complication or without any limitation per se. So yes, for from a business standpoint, this becomes very important for this country to get this in a right way.
Yeah, and I think I was in a conference a few days back, and a very similar thing happened here in India as well. When we are trying to get our own law as a country, we are also thinking a lot about adequacy right now because we want to be adequate because the business, if we want to be a global business place, then we need this, and that's a great understanding. And also, I think when we started, right, when we started this conversation, I think you pointed out saying that also there are free zones and free zones are important in the country, right? And then we kind of discussed that DIFC and ADGM, they have their own privacy laws which are aligned to GDPR. So do you have any perspective as to how the data transfer will happen between UAE and those free zones if the laws are different, and how will they get affected, or what do they have to change as companies over there?
I think, Akash, that's a very, very valid question, that I see will need a lot of attention, both from the upcoming regulation standpoint as well as from the practices that are being followed by DIFC and ADGM. So I have interacted with those regulators. They are pretty flexible, open to thoughts, and they understand what privacy is trying to address. But at the same time, DIFC says that anything that goes out of DIFC, is considered, a data transfer, right? Same goes with ADGM and other, right? So one fundamental difference here is that the scope of these regulation is limited to those, free zones that are there. But what will happen to a business that operates out of that free zone as well as out of the mainland or any other place in the country, right? Plus, I
Yep.
operate out of the main, or I'm covered by the UAE PDPL as well as my processor or my joint controller, or my sub processor is covered by DIFC law, right? So these are the finer operational aspect that actually, once the data office is set up, they need to discuss with DIFC and or ADGM. And I
Yep.
think resonating it with my earlier response, DIFC and ADGM could vice versa give the advocacy certification to each other, and the mainland companies, so that the data movement can freely happen.
Yep.
Because till the time it is within the boundaries of the country, I think the same level of protection applies in most of the aspect, barring few. So that way the business could be made easy, and the exchange of information and the flow of data would become very easy.
I have one last question for you today in this podcast. We had a great discussion in terms of how it works, how is it different, and what type of adequacies we're looking for, not just from a EU angle, but also from internal free zones angle. But one more thing that I have, a lot of people see, we all have also maturing in privacy. Privacy is not new anymore. There's also a lot of maturity that we see in the world. So a very important question that keeps getting asked, right, is also what type of concerns that these dark web patterns come up with. And in terms of consent management, if a lot of world is dependent on consent, then a lot of dark patterns can also be embedded into the organizations around us. So do you think that PDPL, as is, or when it will come, will also have some way to stop, and the UAE data office, right? So will we also, are we also thinking about that as a country?
Sure. And I think from my experience, I can tell you that this concern is rising with each passing day. Currently, if I look at the regulation, right, there's no direct reference or mention that consent arising from dark web pattern should be treated or handled in a particular way. But I think the moment you enter and adopt these principles and or these framework, and take it to your business, you will come and you will stuck to these dark web pattern technologies, right, which are there. So it
Yeah.
could be anything from privacy is occurring to misdirection to confirm sharing to roach motels or to trick questions, right? So all these from a layman perspective, these are the tips and tricks that business you might use to get through or
Yeah.
get or bypass the process. And I
Yeah.
think this needs to be addressed, or else the basic premise of consent requirement will lose the importance. So currently it is not there, but I think the data office will definitely look into it, because I think the questions have been asked around this, and they have to handle such scenarios also.
Yeah.
Because if they don't, then the basic premise will get defeated there.
Right, Mr. Mishra. And also, that's a wrap for today's episode of PrivacyCast. And I want to extend a big thank you to you for sharing your insights. I think very deep insights in terms of how it will be implemented, how it's going to affect. And that is the practical knowledge that you have shared. I hope our audience likes it. And people in the audience, if you like this, if you have a question, please drop that in the comment box. Next week, we are going to see you again, and we are going to have one more episode of PrivacyCast. So stay there, just subscribe to the channel, and we will be back.